I came home from Washington in October to find a paved road on my lake. Not near it, on it. Built across the northern shelf that floods every February, the way it has for 67 years. 109 homes in Summit Ridge Estates HOA had been using it for 2 years. Their president, Preston Calloway, had paved it, posted a "private road, authorized vehicles only" sign, and was charging his own residents $200 a month in maintenance fees. All of it on my land, without permits, without permission, without a phone call. When I told Preston the road was on my property, he smiled and called me ma'am. Said I was confused about the boundaries, said to have my attorney call his. What Preston didn't know was that I spent 30 years as a United States federal judge, the last 6 on the Ninth Circuit Court of Appeals. What he really didn't know was what happens to that shelf every February. When I open the dam gates on the standard maintenance schedule my father wrote in 1962, the lake rises 18 feet. I open the gates on February 15th, the same date I've opened them every year for 6 years. By February 20th, 2 of his residents were stranded in cars on a road submerged under 18 inches of water. By March, the EPA had filed. By April, the FBI indicted Preston on federal wire fraud charges. By December, he was sentenced to 4 years in federal prison. I didn't fight anyone. I opened a gate and let spring happen. Before we jump into today's story, let me know where you're watching from, and be sure to smash that like button and subscribe for more content like this. I'd been away for 2 years. My final federal appointment had kept me in Washington, D.C. longer than expected, a complex environmental litigation case involving multi-state water rights that required my full attention through the summer and into early fall of 2024. I didn't mind. I loved the work. 30 years on the federal bench had never felt like a burden. But by October, it was done. The case was resolved. My appointment had concluded, and I was finally driving home to Montana, home to Lake Voss. I took the scenic route from Missoula, the way I always did. Highway 200 east, then the county road north toward the property. The approach to the lake took you along the northern shore first, a 2-mile stretch of road that hugged the hillside above the water, giving you a sweeping view of the lake before you reached the main gate to my property. It was one of my favorite views in the world. My father had loved it too. He'd stop the car every time we made this drive, even when I was a child, just to look at the water. I reached the familiar overlook and slowed automatically, as I always did. Then I stopped completely. Something was wrong. The northern shelf, the flat expanse of land that extended from the base of the hillside to the lake's edge at the northern end, had always been open, natural, rocky grassland that spent half the year submerged and half the year exposed, depending on snowmelt and lake levels. Now there was a road on it, a paved road, 8 feet wide, fresh black asphalt, white center line, metal guardrails on the lake-facing side, drainage culverts every 100 feet. It ran the full length of the northern shelf, 0.8 miles, connecting what appeared to be 2 sections of the Summit Ridge Estates development on either side. A green sign stood at the western entrance. Summit Ridge Private Road, authorized vehicles only, no trespassing. I sat in my car for a full minute, staring. Then I got out. The October air was cold, sharp with the smell of pine and coming winter. I zipped my jacket and walked down to the shelf. Up close, the road was even more impressive in its audacity. Professional construction, proper drainage infrastructure, road markings freshly painted. Someone had spent real money on this. I walked the entire 0.8 miles. Every step I was calculating. I knew this shelf. I'd played on it as a child. I'd watched it flood every spring for 60 years. My father had taught me to read the waterline markers on the rock face, how the dark staining on the limestone showed exactly how high the lake reached each April. The highest waterline mark I could see was 22 feet above where I was standing. The road was built 12 feet above the current lake level. That sounded safe, except I knew what this shelf looked like in March, when 4 mountain rivers began their snowmelt surge into the lake. I knew what it looked like in April, when the dam gates were partially open for ice management and the lake level climbed steadily. By late February, this road would have water running across it. By March, it would be submerged. By April, it would be 10 feet underwater. I finished walking the road and pulled out my phone. I used the property survey app I downloaded years ago. It pulled directly from county GIS records and overlaid them on satellite imagery. I zoomed into the northern shelf. My property boundary was clear. The line ran along the hillside, then extended across the shelf, then along the lake edge. The entire 0.8-mile road was inside my boundary, every inch of it. I took photographs, systematic, thorough, the way I'd been trained to document evidence over 3 decades on the bench. GPS coordinates for each end of the road, the sign, the guardrails, the drainage culverts, the asphalt surface, the waterline markers on the rock face, the date, October 18th, 2024. Then I checked county records on my phone. No construction permit for a road on this parcel. No easement recorded against my property. No authorization of any kind. The road had been built without permits, without my permission, and in direct violation of my property rights. I drove to the Summit Ridge Estates clubhouse. It was an impressive facility, a large timber frame building with mountain views, a covered entrance, and a parking lot full of expensive vehicles. The kind of place that announced its exclusivity before you walk through the door. Inside, a receptionist directed me to the HOA president's office. His name was on the door in brass letters. Preston Calloway, HOA president. I knocked. "Come in." Preston Calloway was in his late 40s. Tall, fit, silver-templed in the way that expensive haircuts make men look distinguished rather than old. Navy suit, gold cufflinks. The kind of confident posture that comes from years of being the smartest person in whatever room he walked into. He stood when I entered, extending his hand with a practiced smile. "Mrs. Voss, is it? My receptionist said you wanted to see me. Please, sit down." "Thank you." I sat across from his desk. "You built a road on my property." His smile didn't waver. "I'm sorry?" "The road on the northern lake shelf, the one your sign calls Summit Ridge Private Road. It's on my property, built without my permission and without county permits." Preston leaned back in his chair, still smiling, but differently now. The smile of someone who decided this was going to be a simple conversation to manage. "Mrs. Voss, I appreciate you coming in, but I think there may be some confusion. That road was built on county-designated wetland buffer land. We had the property thoroughly surveyed before we broke ground. Our attorneys reviewed everything. Your survey is wrong. Ma'am, we spent $340,000 building that road. I assure you, we did our due diligence." "Then your due diligence failed. That land has been in my family since 1947. My father purchased it as part of the original 3,200-acre parcel. In 1958, he built the Voss Dam, which created Lake Voss entirely within our property boundary. Everything within that boundary, including the northern shelf where you built your road, belongs to me." Preston's smile shifted again, condescending now. Patient in the way people are patient with elderly relatives who've said something confused at dinner. "With all due respect, I think you may be misremembering the boundaries. These things get complicated with older properties. Our survey team was very thorough. I have the original 1947 deed, the 1958 dam construction permits, 4 subsequent property surveys, and 67 years of property tax records. I also have GPS coordinates confirming that every inch of your road falls within my boundary lines. I checked this morning." "Mrs. Voss, Judge Voss," he blinked. "I'm sorry?" "I spent 30 years as a United States federal judge, the last 6 years on the Ninth Circuit Court of Appeals. I'm not confused about property boundaries, and I'm not going to be talked out of what I can confirm with documentary evidence in a survey app." For the first time, Preston's composure flickered. Just slightly, just for a moment. Then it came back. "Judge Voss, I apologize for the informality, but my position remains the same. We had legal counsel review this project thoroughly. If you believe there's a boundary dispute, we can certainly arrange for a joint survey. There's no dispute. It's my land. Your road is trespassing." I stood. "You just made a very expensive mistake." I set my business card on his desk, not the one with just my name and phone number. The one that still listed my judicial credentials. He looked at it. "Have your attorney contact mine," I said. "You'll want to do that soon." I walked out. In my car, I sat for a moment before starting the engine. Preston hadn't taken me seriously. That was fine. Men like Preston rarely took 64-year-old women seriously until it was too late. But I wasn't thinking about the confrontation. I was thinking about something else. On my walk along the road, I'd noticed small signs posted at 50-meter intervals. Modest, easy to miss. Summit Ridge Road Maintenance District. Monthly assessment, active. I'd seen similar language in HOA documents before. It was the kind of language that meant residents were being charged a fee for road maintenance on a road built on my property without my permission. I pulled out my phone and called my former law clerk. Nathan Chen had clerked for me during my final 3 years on the Ninth Circuit, one of the sharpest legal minds I'd worked with in 30 years. He was now a senior attorney with the EPA's Regional Enforcement Office in Seattle. Judge Voss, it's been months. Are you back in Montana? I got home today. Nathan, I need your perspective on something. I described what I'd found. The road, the shelf, the flood cycle, the lack of permits, the maintenance assessment signs. He was quiet for a moment. Judge, is the lake fed by rivers that flow into any downstream navigable waterways? Yes. Lake Voss drains through the outlet creek into the Clark Fork River system. Then the Army Corps of Engineers has jurisdiction. Any unpermitted structure in or affecting navigable waters violates Section 404 of the Clean Water Act. A paved road built across a seasonal flood zone that directly connects to a navigable river system is a textbook violation. That's what I thought. Do you want me to make some calls? Not yet. I want to document everything first. And I want to understand the maintenance fee situation before we move. What maintenance fee situation? They've posted maintenance district signs along the road. HOA residents are apparently being assessed a monthly fee for road maintenance. For a road built on your property without your permission? Correct. Nathan was quiet again, longer this time. Judge, if they're collecting fees for maintenance of an unpermitted structure on private property, and those fees are going somewhere other than actual maintenance costs, that's fraud. That's federal fraud if it crosses state lines or involves wire transfers, which HOA fees almost always do. I know, which is why I want to document the full scope before we do anything. What are you going to do about the road in the meantime? I looked at my father's dam operation manual on the passenger seat. I'd grabbed it from the study before driving out that morning. February 15th, partial gate opening. Increase water flow by 40% for ice management. I'd done it every year for 6 years without fail. I was going to do it this year too. Nothing dramatic, I said. I'm just going to follow my standard maintenance schedule. Nathan understood immediately. I could hear it in his pause. When's your February maintenance? The 15th, as always. And the road sits on the seasonal flood shelf, 12 feet above current water level. The lake rises 18 to 22 feet in spring. Another pause. Judge Voss, you are a deeply methodical woman. I'm a property owner following a maintenance schedule I've adhered to for 6 years. Everything else is just weather. He laughed quietly. I'll be ready when you need me. That evening I sat in my father's study. The room was exactly as he'd left it when he died in 2018. Bookshelves of engineering manuals and legal references, his old drafting table in the corner, the original dam blueprints framed on the wall. He'd built that dam with his own money, his own engineering, and his own vision. He'd created Lake Voss from 4 mountain rivers and a valley that everyone else had dismissed as too remote and too difficult. And in doing so, he'd created something that would outlast him, a lake, a legacy, a property that demanded to be protected. I opened the dam operation manual to the winter maintenance section. February 15th, partial gate opening for ice management. Increase water flow by 40% through primary spillways. Monitor downstream water levels for 72 hours. Standard annual procedure. No special authorization required. I'd followed this procedure every year since inheriting the property. The gates opened February 15th. Water flowed through the primary spillways at 40% increased capacity. The lake level began its seasonal rise. By late February, the northern shelf flooded. Every year, without exception. This year would be no different. I closed the manual and looked out the study window at the darkening lake. Preston Calloway had called me Mrs. Voss and handed me a business card. He'd spent $340,000 building a road on my lake shelf without understanding what that shelf did every winter. He'd dismissed me as a confused old woman who didn't know her own property boundaries. He didn't know I'd spent 30 years ruling on environmental and property law cases from a federal bench. He didn't know I had direct connections to the EPA, the Army Corps of Engineers, and every federal environmental enforcement office in the western United States. And he definitely didn't know what happened to that road every February. But he was going to find out, in approximately 119 days, on schedule, as always. February 15th arrived cold and clear, 6 inches of snow on the ground, temperature at 18 degrees at sunrise, the kind of Montana winter morning that made the mountains look like a painting and reminded you why people either loved this state completely or left it permanently. I was at the dam control house at 7 a.m. The Voss Dam was my father's masterpiece. 75 feet of reinforced concrete rising from the valley floor, holding back 1,100 acres of mountain water. He'd designed it himself, a civil engineer who'd spent 15 years studying Western dam construction before breaking ground in 1958. The control house was small but solid, same concrete construction as the dam itself. Inside, the main gate controls, monitoring equipment, flow gauges, and a logbook that dated back to the dam's first year of operation. I opened the logbook to a fresh page. February 15th, 2025. Annual winter maintenance. Partial gate opening for ice management. Increasing primary spillway flow by 40%. Operator, Eleanor M. Voss. I'd made this same entry every February for 6 years, the same procedure my father had performed for 40 years before me. Before touching the controls, I called the Sanders County Water Management Office. Sanders County Water Management, this is Carol. Good morning, Carol. This is Eleanor Voss at Voss Dam, property ID 47-2281. I'm calling to notify you of our annual February maintenance procedure. We'll be increasing primary spillway flow by 40% beginning this morning for ice management. Standard annual procedure. Thank you, Judge Voss. I'll log it in the system. Any expected duration? Standard. We'll monitor for the next 30 days and adjust as snowmelt begins in March. Understood. Have a good morning. You too. I hung up and noted the call in the logbook. Time, person spoken to, content of notification. The same documentation I'd done every year. Then I turned the primary gate wheel. The mechanism was original to the dam's construction. Large steel wheel connected to cables and gears that controlled the spillway gates at the base of the structure. My father had maintained it meticulously. I'd continued the tradition. 16 turns counterclockwise. The indicator moved from the baseline position to the 40% increased flow marker. I heard the change immediately. A deeper rumble as additional water pushed through the spillways. Below the dam, the outflow creek surged with increased volume, carrying cold mountain water downstream toward the Clark Fork system. Above the dam, the lake's surface was still. Frozen at the edges, open water in the center. But the dynamics had changed. With the spillways flowing at increased capacity, the natural balance of the lake shifted. The inflow from 4 mountain rivers, reduced to winter trickle level in February, would now gradually exceed the outflow. The lake level would begin rising, slowly, predictably, exactly as it had every year for 67 years. I logged the gate position, the time, and the weather conditions. Then I walked outside and stood on the dam's observation platform. I looked north toward the shelf where Summit Ridge's road sat at 12 feet above the current water line. I didn't do anything else. I didn't make any additional gate adjustments. I didn't increase flow beyond the standard 40%. I just followed the maintenance schedule my father had written in 1962 and walked back to my house for breakfast. By February 17th, 2 days in, the lake level had risen 14 inches. Not enough to touch the road yet, but enough to be visible. The rock face markers, which I checked every morning with binoculars from my porch, showed the steady climb. I logged it in my maintenance records. Routine. By February 19th, 4 days in, the lake was up 3 feet. Still not touching the road, but the northern shelf was visibly wetter. Water was seeping up through the gravel substrate, saturating the ground beneath the road's drainage culverts. I photographed the waterline markers every morning. GPS stamped, date stamped, time stamped. Documentation. On February 20th, 5 days after opening the gates, I received a call from a number I didn't recognize. Judge Voss, this is Deputy Marcus Webb, Sanders County Sheriff's Office. We're out at your property, the northern section, near the Summit Ridge development. We've had some vehicles stranded in water on a road out here. Are you available to come out? I set down my coffee. I'll be there in 15 minutes. I arrived at the Northern Shelf Access Road to find a scene that was equal parts emergency response and chaos. Two vehicles were stranded in the road's midsection, a black SUV and a silver sedan, both with water at door panel level. The road's surface was submerged under approximately 18 inches of water across a 40-foot section where the shelf dipped lowest. A fire department truck was parked at the eastern end. Two firefighters and waiters were working to attach tow lines to the stranded SUV. 3 sheriff's deputies were on scene, including Deputy Webb, who met me at my car. "Judge Voss, thank you for coming. Are you the property owner of this parcel?" He gestured toward the shelf. "I am, all of it, including the shelf where that road was built." He looked at his notepad. "Can you confirm the property ID and boundary?" I handed him a folder I'd brought from home. It contained the property deed, the most recent survey from 2019, and the dam operation permit listing my ownership of the full 3,200-acre parcel. He reviewed it for a moment, then looked up at the road. "Judge, did you know this road was here? I discovered it in October, when I returned from Washington. I have documentation of my discovery, including photographs and GPS records. Did you authorize its construction?" "No. I have no record of any easement request, permit application, or permission sought by Summit Ridge Estates or any of its representatives." Deputy Webb made notes. Across the water, I could see Preston Calloway standing at the eastern end of the road. He was wearing a heavy coat over what appeared to be business attire, his expensive shoes thoroughly unsuited for the wet gravel he was standing on. He was on his phone, animated, pointing at the water. He saw me arrive. He ended his call and walked around the perimeter of the flooded section toward us, moving fast. "What is going on?" he demanded, arriving breathless. "Who authorized flooding this road? We have 2 vehicles stuck." Deputy Webb held up a hand. "Sir, I'll get to you in a moment. I'm speaking with the property owner." Preston stopped. He looked at me. Recognition crossed his face. You did this." "Good morning, Mr. Calloway. You flooded our road deliberately." "I conducted routine dam maintenance on the standard annual schedule." I looked at Deputy Webb. "I notified Sanders County Water Management at 7:04 a.m. on February 15th. I have the call log." I showed him my phone, the logged call, the time, the county office number. Deputy Webb noted it. "I open these gates every February 15th, I continued. "I have 6 years of maintenance records showing this exact procedure performed on this exact date every year." The lake level rises in late February as a natural result of reduced outflow during ice management. This shelf has flooded every February for 67 years. "She planned this!" Preston's voice had risen. Several of the firefighters glanced over. "She found out about our road and deliberately timed this to destroy it." "Mr. Calloway," Deputy Webb's voice was steady and authoritative. "I need you to lower your voice. We have an active rescue operation happening." "She's using her dam as a weapon." "Sir," the deputy's tone sharpened. "I said lower your voice." Preston stopped talking, jaw clenched. Deputy Webb turned back to me. "Judge Voss, to your knowledge, does this road have the necessary permits for construction on this parcel?" I checked county records in October after discovering the road. At that time, there was no construction permit, no grading permit, and no easement of any kind recorded against my property. The deputy looked at Preston. "Mr. Calloway, do you have documentation showing permits for this road's construction? We had a survey conducted that showed this land was county wetland buffer. Do you have permits issued by Sanders County for road construction on this parcel?" Preston hesitated. The survey indicated, "Yes or no, sir. Do you have county permits?" A longer hesitation. "The permitting situation is being reviewed by our attorneys." Deputy Webb wrote something in his notepad. One of the firefighters called out. The SUV was free, being towed to the eastern bank. The sedan was next. I watched the operation calmly. Preston moved closer to me, lowering his voice to something between a demand and a hiss. "You timed this. You waited until residents were using the road, and then you flooded it. Do you know how dangerous that was? Those people could have been injured." I looked at him directly. "Your HOA built a road on a seasonal flood shelf without permits, without my permission, and without informing residents that the road floods every February. If anyone endangered those drivers, it was you. This is my property. It is not your property. I showed you in October that this is my property. You dismissed me. You said, and I'm quoting from memory, that I was confused about the boundaries, and I should have my attorney contact yours. I gestured toward the water. This is what confused looks like in February. Preston's face went red. You'll hear from my attorneys by end of business today. I expect I will. Please have them contact David Marsh. He's been handling my property matters for 12 years. I handed him one of my cards. And Mr. Calloway, I'd suggest having them review the Army Corps of Engineers permit requirements for structures in navigable water zones. Your road sits in the Clark Fork Tributary System's regulated area. Preston looked at the card, then at me. You're a judge. Retired. But the federal contacts don't retire with the robe. I turned back to Deputy Webb. Deputy, do you need anything further from me today? No, ma'am. Judge, I have what I need for now. We'll be filing an incident report, and I expect the county building department will want to review the permit situation. Of course, I'm available whenever needed. I handed him a second document from my folder, a one-page summary I'd prepared in October showing the property boundary, the location of the road, and the annual waterline data for the past 6 years documenting the flood cycle on the northern shelf. He looked at it with obvious interest. You prepared this in October? When I discovered the road, I document everything, Deputy. 30 years on the federal bench is a hard habit to break. I drove home. On my porch, I refilled my coffee and called Nathan Chen in Seattle. Nathan, the road flooded this morning. 2 vehicles stranded. Sheriff responded. Any injuries? None. Fire department got both vehicles out safely. How did the HOA respond? Preston Calloway accused me of deliberate flooding. I provided the sheriff with 6 years of maintenance records, the county notification from February 15th, and the property survey. The sheriff is now asking the county building department about permits, which do not exist. Judge, once the county building department confirms no permits were issued, this becomes an official, unpermitted structure case. Standard procedure is a stop work order and an abatement notice requiring removal. I know the procedure. And once they notify the Army Corps, which they're required to do if the structure is in a navigable water zone, the federal clock starts ticking. Yes, Clean Water Act Section 404 violations carry penalties of up to $25,000 per day. Per day, Judge. I looked out at the lake. The water was still rising slowly, steadily, the way it always did. Nathan, I'd like you to make a call. Not officially yet. Just a conversation with your Army Corps contact about a hypothetical unpermitted road structure in the Clark Fork tributary area. I can do that, hypothetically. Thank you. Judge, this is going to get much bigger than a road. I know. I hung up and opened my maintenance logbook. February 20th, 2025. Lake level plus 36 inches from baseline. Northern shelf flooding confirmed. Sheriff response. Incident report filed. County Building Department inquiry initiated. All consistent with normal annual flood cycle. Routine, exactly as scheduled. The Sanders County Building Department moved faster than I expected. By February 22nd, just 2 days after the vehicles were stranded, a county inspector named Gary Whitfield had walked the flooded road, reviewed the permit database, and issued his finding. No grading permit. No road construction permit, no drainage alteration permit, no floodplain development authorization, nothing. Summit Ridge Estates had built 0.8 miles of paved road, installed 12 drainage culverts, placed guardrails, and applied road markings, all without a single permit from Sanders County. Gary Whitfield issued a formal notice of violation on February 24th. The notice required Summit Ridge HOA to immediately cease use of the unpermitted structure, submit a full engineering assessment within 30 days, provide documentation of ownership rights to the land where the structure was built, appear before the County Building Review Board within 45 days. I received a courtesy copy because my property deed was attached to the incident report. I filed it neatly in the growing folder labeled Summit Ridge Road Documentation. That same week, Gary Whitfield did something the county was legally required to do once an unpermitted structure near water was identified. He notified the Army Corps of Engineers. The notification went to the Army Corps' Omaha district, which had jurisdiction over Montana waterways. It was a routine referral, standard procedure when unpermitted construction potentially affected regulated waters. What wasn't routine was what happened next. The Army Corps assigned the case to their Regulatory Enforcement Division within 48 hours, instead of the standard 2-week processing time. That acceleration had Nathan Chen's fingerprints on it. He called me on February 26th. "Judge, the Army Corps is moving. I made some calls." "How fast are they moving?" "Fast. The Clark Fork tributary designation makes this straightforward. Any structure affecting water flow into a navigable river system requires a Section 404 permit under the Clean Water Act. No permit exists. That's a violation, open and shut." "What about the drainage culverts?" Nathan paused. "That's actually worse than the road itself. Our field team looked at the photos you sent. The culverts are installed at the wrong grade. Instead of directing seasonal overflow away from the road surface, they're channeling it directly into the substrate beneath the road. That's been causing subsurface erosion of the lake shelf since the road was built." "How bad?" "The erosion is tracking downstream through the substrate and emerging in the outlet creek. There's visible bank erosion about 400 meters below the dam that wasn't there in the 2022 satellite imagery. Someone who knows what they're looking at can draw a direct line from the culvert installation to the downstream erosion." I closed my eyes for a moment. My father had spent years stabilizing that creek bank. So we have unpermitted road in a regulated waterway zone, improper drainage causing active erosion, and downstream impact on a Clark Fork tributary. Yes, EPA is prepared to open a formal enforcement action. I need your authorization to move forward officially. You have it. Judge, when we file this, it becomes public record. Preston Calloway is going to see federal agencies coming from multiple directions simultaneously. Good. He should have thought about that before he built a road on my lake. Nathan filed the formal EPA enforcement referral on March 3, 2025. The EPA issued 2 documents simultaneously. First, a formal notice of investigation under the Clean Water Act, citing potential Section 404 violations for unpermitted fill material in waters of the United States. Second, a cease and desist order prohibiting any use of the Summit Ridge road structure pending investigation. Both documents were served on Summit Ridge Estates HOA and on Preston Calloway personally, because, as the HOA president and the attorney of record who had approved the construction, he was named as a responsible party. Preston's response was immediate and predictably wrong. He called a press conference. I watched the local news coverage that evening. Preston stood in front of the Summit Ridge clubhouse in his best suit, flanked by 2 attorneys I didn't recognize. "The EPA's action is completely without merit," he said, his voice carrying the practiced confidence of a real estate attorney who'd spent 20 years intimidating smaller parties. "This is a private road on private community land. The EPA has no jurisdiction over private property roads. This is government overreach, plain and simple, and we will fight it vigorously." A reporter asked, "Mr. Calloway, the county has confirmed the road was built without permits. How do you respond?" "The permitting situation is being addressed. Retroactive permits are a standard part of the building process when administrative oversights occur." Another reporter, "Is it true the road is built on land owned by retired Judge Eleanor Voss?" Preston's composure flickered for just a fraction of a second. "That is a matter under review." I turned off the television. The next morning, I called David Marsh, my property attorney. "David, I'd like you to send a formal letter to Preston Calloway's attorneys. Standard trespass notice. My property, no permission granted. Demand for cessation of all use and beginning of remediation planning." Done. "Do you want to include a damages figure?" "Not yet. Let the federal process develop first. The EPA and Army Corps will do most of the work. I just want a clean paper trail showing I notified them formally through legal channels." Wise. "I'll have it out today." David's letter arrived at Preston's office the same afternoon as a letter from the Army Corps of Engineers. The Army Corps letter was detailed and specific. It cited the Clark Fork River as a traditionally navigable water of the United States. It cited Lake Voss as a tributary water body connected to that system. It cited the Summit Ridge Road as an unpermitted structure, placing fill material in regulated waters, specifically the gravel and asphalt base layers that had been laid across the seasonal flood shelf. And it cited the drainage culverts as an unpermitted alteration of water flow in a regulated waterway. The violation notice carried a preliminary assessment of $18,500 per day in potential civil penalties, calculated from the road's construction date in early 2023 through the present. 24 months of violation at $18,500 per day. I did the math. $13.3 million in potential exposure before a single court filing. 3 days later, I was sitting on my porch watching the lake when I heard vehicles approaching. 2 of them, Preston's Range Rover and an unfamiliar sedan. They parked at the edge of my access road, and 4 people got out. Preston and 3 others. 2 looked like attorneys. 1 I didn't recognize. Preston walked up to my porch. His confident posture from the press conference was noticeably diminished. "Judge Voss, I'd like to speak with you." "Go ahead. In private, if possible." "This is my porch, Mr. Calloway. Say what you came to say." He squared his shoulders. "The EPA has no jurisdiction over this road. It's a private structure on what we surveyed as private land. Their cease and desist is legally invalid, and we're going to challenge it. The EPA has jurisdiction over any structure affecting waters of the United States. My lake feeds directly into the Clark Fork system. The Army Corps confirmed that classification. Your road sits in their regulated zone." "That's a stretch. It's federal statute, Clean Water Act Section 404. I've ruled on similar cases. The jurisdictional standard is well established. You're a retired judge. You can't use your federal connections to weaponize government agencies against a private HOA." I looked at him steadily. "I didn't call the EPA, Mr. Calloway. The county building inspector called the Army Corps. That's a mandatory referral under Montana State Code when unpermitted construction is found near water. The Army Corps referred to the EPA. That's their standard interagency protocol. I made one call to a former law clerk who works at the EPA to let him know the referral was coming. Everything that's happened since has been standard regulatory procedure." Preston stared at me. "You're hiding behind process." "I'm following the law, which is more than you did when you built that road." One of the men behind Preston stepped forward, younger, probably his personal attorney. "Judge Voss, my client is prepared to discuss a resolution, perhaps a retroactive easement arrangement, some form of compensation. Your client built an unpermitted road on my property, is now facing federal environmental violations that predate any easement negotiation, and is personally named as a responsible party by the EPA. Before we discuss easements, your client needs to address the federal violations. I can't grant an easement on a road that the Army Corps has ordered stopped." The young attorney looked at Preston. Preston's jaw tightened. "What about the cease and desist on road use?" Preston asked. "Our residents need that road. Your residents need to use the alternative route through Summit Ridge until the federal process is resolved. That's not my decision. That's the EPA's order." Preston turned and walked back to his vehicle without another word. His attorneys followed. I watched them leave, then called Nathan. "Preston just came to my property. He's trying to argue EPA jurisdiction. He'll lose that argument in 5 minutes if he actually files a challenge. The Clark Fork designation is solid and has been upheld 3 times in the 9th Circuit." "I know. He knows it too, probably. He was posturing." I paused. "Nathan, what's the timeline on the Army Corps assessment?" "Field inspection is scheduled for March 12th. Once they document the culvert damage in person, the violation notice becomes a formal compliance order. That triggers a 30-day response period, then potential administrative penalty proceedings." "And the $18,500 per day figure? That's the preliminary assessment based on the structure's dimensions and the waterway classification. The formal figure could be higher once they assess the downstream erosion damage." I thought about the creek bank below the dam, my father's stabilization work slowly being undone by incorrectly installed culverts. "What about personal liability? Preston approved this as the HOA's attorney of record." That's where it gets interesting. When a licensed attorney signs off on construction that violates federal environmental law, Their personal liability exposure is significant. His bar association will almost certainly be looking at this. I said nothing for a moment. In my 30 years on the bench, I'd seen dozens of cases where someone's arrogance had cost them everything. The pattern was always the same. An initial advantage, money, status, local connections, made them feel untouchable. They dismissed the person across from them. They escalated when they should have retreated. And by the time they understood the full scope of what they'd done, it was too late to stop the consequences. Preston had called me ma'am. He'd told me I was confused. He'd built a road on a seasonal flood shelf and charged his own residents for maintaining it. And now he was looking at federal environmental violations, personal legal liability, and a bar association inquiry. Nathan, I said, one more thing, the maintenance fees. The signs on the road said Summit Ridge Road Maintenance District, monthly assessment, active. I've been meaning to look into what that actually means financially. You think there's something wrong with the fees? I think Preston Calloway is a man who built a $340,000 road on someone else's property and charged his residents for it. I'd like to know exactly how much they've been charged and where that money went. Nathan was quiet for a beat. I'll make a call to the Montana AG's Consumer Protection Division, unofficially, just to see if there's an existing complaint. Thank you. I hung up and opened my logbook. March 4th, 2025. EPA cease and desist active. Army Corps violation notice issued. Preston Calloway visited property. Declined to negotiate. Field inspection scheduled March 12th. Road maintenance fee inquiry initiated. The water was still rising. The lake was at 4 feet above baseline now. The road was completely invisible under the surface. Not just the low section, but the full 0.8 miles. 8 feet of fresh asphalt, and $340,000 worth of construction, resting quietly on the bottom of my lake, where it would stay until someone paid to remove it. And based on the federal process now fully in motion, that someone was going to be Summit Ridge Estates HOA, or Preston Calloway personally, quite possibly both. The maintenance fee question unraveled faster than I expected. Nathan's contact at the Montana Attorney General's Consumer Protection Division called him back within 48 hours of his inquiry. There were already complaints on file, 3 of them, filed by Summit Ridge residents in January and February 2025, before the road flooded, before the EPA investigation, before any of the federal process had begun. 3 homeowners had independently asked the HOA board for a financial accounting of the Summit Ridge Road Maintenance District fees, and received no response. Nathan forwarded me the complaint summaries. All 3 said essentially the same thing. We have been charged $200 per month since January 2023 for road maintenance. When we requested documentation showing how these funds are being used, HOA President Preston Calloway told us the accounting was proprietary HOA management information and declined to provide it. Proprietary. In 30 years on the federal bench, I'd heard a lot of words used to conceal financial misconduct. Proprietary was among the most common. I called David Marsh. David, I want to file a civil suit against Preston Calloway and Summit Ridge Estates HOA. Trespassing, property damage, and unjust enrichment. I also want to formally request a full financial accounting of the road maintenance fees as part of discovery. When do you want to file? This week. While the federal investigations are active, I want the civil suit running parallel to the regulatory process. David filed on March 10, 2025. The complaint was 14 pages. It documented the trespass, construction of a road on my property without permission, the property damage, erosion caused by improper culvert installation, and unjust enrichment. The HOA had benefited commercially from unauthorized use of my property, but the filing also included a specific discovery demand, full financial records for the Summit Ridge Road Maintenance District from its inception through the present. 2 things happened simultaneously after that filing. First, a faction of Summit Ridge homeowners who'd been quietly organizing since the road flooded obtained a copy of the civil suit through the court's public records system. Second, they hired their own attorney and their own forensic accountant. The forensic accountant's name was Patricia Drummond, out of Missoula. She had 20 years of experience in HOA financial fraud cases. She started with the basics. Total road maintenance assessments collected, 180 homes, $200 per month, 24 months of collection, January 2023 through December 2024. 180 times $200 times 24 equals $864,000. She then requested all HOA financial records through the homeowner faction's attorney. The HOA board, still controlled by Preston's appointees, resisted for 2 weeks before the Montana AG's office sent a formal records demand. The records arrived in a banker's box. Patricia Drummond went through them line by line. She called me directly after David connected us. Her voice was the measured tone of someone who'd found exactly what she'd expected to find, and was quietly furious about it. Judge Voss, I've completed my preliminary analysis of the Summit Ridge HOA financial records. What did you find? The road construction cost $340,000. That payment went to a company called Callaway Construction, LLC. I already knew what was coming. And who owns Callaway Construction, LLC? Preston Callaway. It was formed in November 2022, 2 months before road maintenance fee collection began. He created the company, awarded his own company the construction contract, and paid himself $340,000 from HOA funds. So he collected $864,000, paid his own company $340,000, and has $524,000 remaining. That's where it gets worse. The remaining $524,000 didn't sit in the HOA account. It was dispersed through a series of invoices to a legal services firm called PCL Consulting Group. And PCL Consulting Group is Preston Callaway Law, his personal legal practice, billed to the HOA as ongoing legal consulting related to road maintenance district administration. 24 monthly invoices, each for approximately $21,800. I sat with that for a moment. It was brazen, genuinely, remarkably brazen. He'd created a fake maintenance fee, collected $864,000 from 180 families, paid himself $340,000 through his construction company for building an illegal road on someone else's property, then pocketed the remaining $524,000 through fraudulent legal consulting invoices to his own law firm. All of it documented, all of it traceable, all of it in the financial records he'd tried to withhold. Ms. Drummond, I'll need a copy of your full analysis for our civil suit discovery. David Marsh has already requested it. You'll have it by end of week. Thank you. I hung up and sat quietly for a moment. Then I called Nathan. Nathan, the fraud is worse than we thought. I walked him through Patricia Drummond's findings. He was quiet for a long moment. Judge, $524,000 in fraudulent invoices across 24 months, collected via HOA assessments from 180 homeowners. If those funds were transmitted electronically, which HOA fees almost always are, that's wire fraud, federal jurisdiction. I thought as much. I'm going to call the FBI field office in Missoula. This is beyond the AG's Consumer Protection Division. Make the call. The Montana AG's office had already begun their own process. On March 15th, they sent formal investigative demands to Preston Callaway and Summit Ridge Estates for all financial records related to the road maintenance district. The same day, they filed a formal referral to the Montana State Bar Association, requesting a review of Preston's conduct as both the attorney who approved the road's construction and the HOA president who structured the maintenance fee. The bar referral cited 3 potential violations. Rule 1.8, conflict of interest, attorney transacting business with a client, the HOA, where the attorney has a personal financial interest. Rule 8.4, C, conduct involving dishonesty, fraud, or deceit. Rule 8.4, D, conduct prejudicial to the administration of justice. Preston's law license was placed under interim review pending the bar investigation. He could still practice, but the notice of review was public record. His 3-attorney firm in Missoula lost 2 clients within a week of the notice being published. On March 18th, the homeowner faction held a special meeting. I wasn't there, but David attended as an observer since my civil suit was directly connected. He called me afterward. It was volcanic, Maggie. 142 of the 180 homeowners showed up. Patricia Drummond presented her findings. There were people crying. One man stood up and said he and his wife had put off their daughter's college fund contribution to cover the road maintenance assessments. Another woman said she'd specifically asked Preston about the fees in October, and he'd told her it was for long-term infrastructure maintenance and future road expansion. Future road expansion on my property. Apparently, the vote was unanimous. All board members appointed by Preston were removed. A new 5-person emergency board was elected. Their first act was to hire Patricia Drummond as the HOA's own forensic accountant and to file their own civil suit against Preston. So now he's being sued by me and by his own HOA, and investigated by the Montana AG, referred to the state bar, and, as of this morning, contacted by the FBI. I let that settle. How did he respond? Preston released a statement through his personal attorney. I'll read it to you. The financial arrangements related to the Summit Ridge Road Maintenance District were fully compliant with HOA governing documents and standard management practices. Any suggestion of impropriety is without merit and politically motivated. Politically motivated? By a retired judge who just wants her lakeshore back. That's essentially the subtext. I heard David shuffle papers. Maggie, the FBI contact was informal. They reached out to his personal attorney to request a voluntary interview. He declined. That means, if they proceed formally, it'll be a grand jury subpoena. And his construction records? Our discovery request and the AG's records demand both hit simultaneously. His attorney tried to assert attorney-client privilege over the Callaway Construction LLC records, arguing they were intertwined with his legal practice. That argument won't hold. Callaway Construction is a separate LLC. The corporate veil is distinct from attorney-client privilege. The magistrate agreed. The subpoena was upheld this morning. His construction records are being produced by end of week. I stood and walked to my study window. Outside, the lake was high and gray under March clouds. The northern shelf was still fully submerged. Not even the guardrail posts were visible anymore. $800,000 in fraudulent fees. $500,000 pocketed, an illegal road, federal environmental violations, an HOA he'd systematically defrauded. And it had all started because he'd dismissed me as a confused old woman who didn't know her own property. On March 22nd, the construction records were produced. Patricia Drummond reviewed them in 2 days. Her supplemental report was devastating. The actual cost to construct the road had been $218,000, not $340,000. Preston had paid his own company $340,000 from HOA funds, pocketed a $122,000 markup on top of actual costs, and then used the remaining $524,000 in fake consulting fees to take another $500,000. Total personal enrichment, $646,000, from 180 families who'd been told they were paying to maintain a road that was built on someone else's property. I filed an amended civil complaint the same day, increasing the unjust enrichment claim to reflect the full scope of funds misappropriated in connection with the trespass on my property. Preston's personal attorney called David that evening. His client would like to discuss settlement. David looked at me. I nodded. "We're listening," David said. His client is prepared to acknowledge the trespass, contribute to road removal costs, and pay a negotiated damages figure to Judge Voss. In exchange, he's asking for a release of civil claims. What figure is he proposing? $150,000. David looked at me again. I shook my head once. "No," David said. "Our client has sustained documented damages, including erosion of her property, unauthorized use of her land for 2 years, and reputational harm from having her property associated with a fraudulent scheme. We're seeking $600,000 in civil damages. Additionally, any settlement must include Preston Callaway's full cooperation with the EPA, Army Corps, and any law enforcement investigations. We will not release claims in a way that impedes criminal proceedings. $600,000 is non-negotiable, and frankly, given what the construction records show, his client should consider accepting before the FBI moves from informal to formal." Preston's attorney called back the next morning. He'll accept $600,000 and full cooperation. I signed the settlement agreement on March 28, 2025. $600,000. Full cooperation with all pending investigations. and a formal, written acknowledgement that the road had been built on my property without permission. The money wasn't the point. The acknowledgement was. The federal grand jury indicted Preston Calloway on April 14, 2025. 4 counts of wire fraud, 1 count of embezzlement, 1 count of making false statements to a federal regulatory agency. Specifically, his claim to the Army Corps of Engineers that the road had been properly surveyed and permitted. The indictment was unsealed at 9 a.m. By 9:30 a.m., it was on the front page of the Missoula Independent's website. By noon, it had been picked up by the Associated Press. By evening, Preston Calloway's name was trending on Montana's social media. I read the indictment carefully at my kitchen table. It was thorough, 31 pages. The U.S. Attorney's Office had done excellent work. Count 1 through 4, wire fraud, covered the monthly HOA fee transfers. Each electronic transfer of the $200 monthly assessments from 180 homeowners to the HOA account, and then from the HOA account to Calloway Construction LLC and PCL Consulting Group, constituted a separate wire fraud event under 18 U.S.C. Paragraph 1343. Count 5, embezzlement, covered the full $646,000 in personal enrichment. The $122,000 construction markup paid to his own company above actual costs. The $524,000 in fraudulent consulting invoices billed to himself. Count 6, false statements, covered his representations to the Army Corps that the road was legally permitted and properly surveyed. Each wire fraud count carried a maximum of 20 years. The embezzlement count carried 10. The false statements count carried 5. Preston was looking at a theoretical maximum of 95 years. That was never going to happen. But even a fraction of it would end his life as he'd known it. His personal attorney issued a statement. Mr. Calloway denies all charges and will vigorously defend himself. These allegations represent a politically motivated prosecution, driven by the personal vendetta of a former judge. I was a retired federal judge who just wanted her lakeshore back. But sure, political vendetta. The same week as the indictment, 2 other institutions moved. The Montana State Bar Association suspended Preston Calloway's law license on an interim basis pending resolution of the criminal charges. Under Montana bar rules, an attorney under federal indictment for crimes involving dishonesty or fraud is subject to immediate interim suspension. Preston's license was suspended within 72 hours of the indictment being filed. His 3-attorney firm in Missoula dissolved within 2 weeks. His 2 partners issued a joint statement dissociating themselves from Preston's conduct and rebranding under a new firm name. 22 years of legal practice, ended by a road built on the wrong person's property. On April 22nd, the EPA issued its formal penalty assessment. After the Army Corps field inspection in March had documented the culvert erosion damage in detail, the EPA calculated their Clean Water Act violation penalties. The road had been in place since March 2023, 25 months. The EPA assessed penalties at $7,400 per day for the unpermitted fill material violation, a reduced rate from the preliminary assessment, reflecting the HOA's cooperation with the investigation. 25 months times 30 days times $7,400 equals $5.55 million theoretical maximum. But the EPA exercised prosecutorial discretion, reducing the assessed penalty to $180,000 based on the HOA's cooperation, the absence of intentional environmental damage, and the relative small scale of the downstream erosion. $180,000, payable within 90 days. The Army Corps issued their compliance order the same week. The road had to be removed. Every inch of asphalt, every drainage culvert, every guardrail post. The substrate had to be excavated, the natural grade restored, and the shoreline revegetated. The Army Corps estimated removal and restoration costs at $400,000. The HOA had 120 days to begin work and 180 days to complete it. And then there was my settlement, $600,000, already agreed and signed. I sat with David the morning after the EPA and Army Corps orders were issued. He laid out the numbers on a legal pad. EPA penalty, $180,000. Army Corps road removal, $400,000. Eleanor's civil settlement, $600,000. Legal fees incurred by HOA, $220,000. Total, $1,400,000. What are their reserves? I asked. New board provided full financial disclosure as part of the AG investigation. Current HOA reserves, $312,000. Annual dues revenue, approximately $540,000. But $380,000 of that goes to operating expenses, insurance, maintenance, staff. So, net annual surplus is around $160,000. Yes, which means even if they applied every dollar of reserves and every dollar of surplus for the next 5 years, they couldn't cover $1.4 million. What about special assessment? They could theoretically assess each homeowner, but the new board commissioned an attorney opinion. Given the circumstances, the fraud, the criminal charges, the federal violations, a significant number of homeowners would likely challenge the assessment or sell their homes. The board is concerned that a large special assessment would trigger a wave of departures that further destabilizes the HOA's finances. So they can't pay. Not without outside funding, and no bank is going to lend money to an HOA facing federal environmental violations and with its former president under federal indictment. The new HOA board, Thomas Erickson, president, a retired architect who'd moved to Summit Ridge in 2020, called me directly on May 2nd. Judge Voss, I need to be honest with you. We cannot meet our financial obligations. We've explored every option. We're going to have to file for receivership. I understand. I want you to know, on behalf of the homeowners who had nothing to do with what Preston did, I'm sorry. You were right from the beginning. This never should have happened. No, it shouldn't have. The receiver will prioritize the EPA fine and the Army Corps removal. Your settlement will be paid from whatever assets remain after those obligations. I paused. Mr. Erickson, the EPA fine and the Army Corps removal are non-negotiable federal obligations. My settlement is a civil agreement. I'll agree to move to the back of the payment queue. The environmental obligations come first. He was quiet for a moment. That's very generous, Judge Voss. It's practical. The lake has to be restored regardless of who gets paid when. That matters more to me than the order of payment. Summit Ridge Estates filed for Chapter 11 receivership on May 15, 2025. The court appointed a receiver, a financial administrator named Karen Lund from Billings, to manage the HOA's assets and obligations. Karen Lund's first act was to freeze HOA accounts and conduct a full financial audit. Her second act was to begin negotiating payment schedules with the EPA and Army Corps. Her third act was to hire the road removal contractor. Summit Excavation and Environmental Restoration began work on June 3rd. They started at the eastern end of the road and worked west. The lake level had dropped back to near normal by June. The winter maintenance period was over, the gates were back to standard position, and the natural drainage cycle had reduced the flood level. The road was exposed again. 8 months underwater had not improved it. The asphalt was cracked and heaved in multiple sections. The culverts were partially collapsed. The guardrails were bent and rusted. It took 11 weeks to remove everything. On August 19, 2025, the last section of asphalt was lifted from the northern shelf and loaded onto a flatbed truck. I watched from the hillside, just me and my binoculars and a cup of coffee. The shelf looked raw and scarred. Exposed substrate, grading marks, equipment tracks. But it was clear, and it was mine. On September 8th, Preston Calloway appeared in U.S. District Court in Missoula. He entered a guilty plea to 1 count of wire fraud and 1 count of embezzlement. The plea agreement dismissed the remaining 4 counts in exchange for his cooperation with the ongoing HOA civil proceedings and full restitution. Sentencing was scheduled for December. On December 12, 2025, U.S. District Judge Harold Pierce sentenced Preston Calloway to 4 years in federal prison and ordered him to pay $646,000 in restitution to the 180 Summit Ridge homeowners he'd defrauded. The courtroom was packed with Summit Ridge residents. I wasn't there. I was at home, sitting on the porch of my father's house, watching snow fall softly on Lake Voss. David texted me the verdict. 4 years. Full restitution. It's done. I put the phone in my pocket and looked out at the lake. The northern shelf was buried under 6 inches of snow. In spring, it would flood again, as it always had. But this time, there would be nothing there to damage, just water, rising over open land, the way it had been for 67 years before Preston Calloway decided to pave it. The restoration contract was signed on September 22nd, 2025. Alpine Ecological Restoration, a firm out of Bozeman with 20 years of experience restoring disturbed Montana shorelines, was hired using the $600,000 settlement funds. Their scope of work covered everything: grading the scarred shelf back to its natural contour, rebuilding the eroded creek bank below the dam, and replanting the entire disturbed area with native vegetation. The project manager, a quiet woman named Dr. Sarah Okafor, walked the property with me before work began. We stood on the northern shelf in late September, the lake at its normal autumn level, the shelf exposed and raw. The road removal had left deep equipment tracks, exposed subsoil, and a geometric flatness that looked nothing like natural lakeshore. Dr. Okafor crouched and picked up a handful of the disturbed substrate, turning it over in her hand. The base soil is actually in good condition, below the compacted layer. Once we break up the compaction and restore the natural grade, native species should establish quickly. How long for full restoration? 2 to 3 growing seasons for complete coverage, but you'll see significant progress by next summer. Montana shoreline species are resilient. My father planted native grasses along this shelf in the 1970s. I have photographs showing what it looked like. Her eyes lit up. Can I see them? We can use historical photos as a restoration target. It makes a significant difference to have a baseline reference. I brought out my father's old albums that evening. We found 12 photographs from the 1970s and 1980s showing the northern shelf: thick blue stem grass, wild bergamot, streambank wheatgrass, and the distinctive rocky outcroppings that had been partially buried under the road's aggregate base. Dr. Okafor photographed each image carefully. This is exactly what we need. We'll match the species composition to your father's original planting wherever we can. Work began October 1st. The restoration crew spent the first 2 weeks breaking up compaction and removing the aggregate base material the road contractor had laid as a foundation. The gravel and crushed stone came out in truckloads, hauled back to a materials yard where it could be repurposed. Beneath the aggregate, the original shelf substrate emerged, the same rocky glacial soil that had been there for 10,000 years before Preston Calloway decided to pave over it. The creek bank repair below the dam took a separate 3-week effort. The erosion had undercut a 40-foot section of the bank, creating an overhang that was slowly collapsing into the outlet creek. The crew installed bioengineered bank stabilization, a combination of native root mat transplants, rock toe protection, and erosion control fabric that would allow vegetation to re-establish while preventing further bank failure. My father had stabilized that same bank in 1974, using techniques that were considered advanced for the time. 60 years later, his granddaughter's settlement money was restoring what a fraudster's culverts had undone. I thought about that often while watching the crew work. By the end of October, the grading was complete. The shelf had its natural contour back, the gentle slope toward the water's edge, the rocky outcroppings emerging from the restored grade, the subtle undulations that gave the shoreline its character. Dr. Okafor's crew began planting on November 3rd, racing the winter freeze. They worked in organized rows, pressing dormant native plugs and seed mixes into the prepared soil. Bluestem grass, wild rye, streambank wheatgrass, native sedge along the water's edge, serviceberry and red osier dogwood shrubs at the upper margin where the shelf met the hillside. The planting was finished on November 12th, 2025. That afternoon, I walked the shelf alone. The ground was covered in a thin layer of straw mulch, protecting the dormant plantings. The rocky outcroppings stood clear. The water's edge was clean and natural. If you hadn't known there'd been a road here, you might not have guessed. By spring, you definitely wouldn't know. I stood at the western end of the shelf where the Summit Ridge sign had been. Summit Ridge, private road, authorized vehicles only. Now long gone, hauled to a landfill in Missoula with the rest of the road materials. The air was cold and still. The lake was gray-blue under November clouds, its surface perfectly calm. My father had stood in this exact spot in 1958, watching the valley fill for the first time after he closed the dam gates. He'd written about it in his journal, which I still kept in the study. The water came slowly at first, then faster than I expected. By the third day, the valley was changed forever. What had been scrubland and rocky creek bed was becoming something else, something that would last. It had lasted 67 years, and it would last longer than that now. The Summit Ridge homeowners reorganized in November 2025. After the receivership proceedings wound down, a core group of 140 homeowners, those who chose to stay despite everything, formed a new HOA structure. They called it Summit Ridge Community Association. No Preston, no board members who'd served under him. New governing documents written from scratch with strict financial oversight requirements. Thomas Erickson, who'd served as emergency board president during the receivership, was elected as the new association's first president. He called me on November 20th. Judge Voss, the new association has held its first formal meeting. I wanted to let you know a few things. Go ahead. First, the restitution. The receiver has confirmed that Preston Calloway's $646,000 restitution order will be distributed to the 180 homeowners proportionally. Each household will receive approximately $3,580. That's good news for your residents. It helps. Not everything, but it helps. He paused. Second, the new board voted unanimously to adopt a formal policy that no structures, improvements, easement requests, or access claims will ever be made against your property. It's written into our governing documents. Any board member who attempts to pursue any claim against the Voss property is subject to immediate removal. I was quiet for a moment. I appreciate that, Thomas. You were right from the beginning. We had a president who thought he could take what wasn't his and talk his way out of the consequences. He was wrong. The new association understands that. I'm glad. One more thing. We took up a collection among the homeowners. Not as compensation. We know you received the settlement. Just as a gesture. We'd like to donate $12,000 to the Clark Fork Coalition for watershed restoration work, in acknowledgement of the damage done to your property and the tributary system. I didn't say anything for several seconds. That's thoughtful, Thomas. The Clark Fork Coalition does excellent work. It seemed right. After we hung up, I sat for a long time looking out at the lake. In early December, Nathan Chen drove up from Seattle for a few days. He'd been instrumental in the federal investigation, his Army Corps contact, his EPA referral, his call to the FBI field office. Without his help, the federal process would have moved at standard regulatory pace. The road might still be there. We sat on the porch the morning after he arrived, bundled against December cold, watching snow fall on the lake. The surface was beginning to freeze at the edges. By January, it would be solid enough to walk on. In February, I would open the dam gates again. Standard maintenance schedule. The lake would rise. The northern shelf would flood. And this time, there would be nothing there but dormant native grass waiting for spring. Nathan wrapped both hands around his coffee mug. Judge, I've been thinking about this whole thing from beginning to end. October, when you came home and found the road. February, when you opened the gates. March, when the EPA filed. September, when Preston pled guilty. He shook his head slowly. You never raised your voice once. Raising your voice is for when you don't have the evidence. He smiled. Was it worth it? All of it. The legal process, the federal agencies, the months of documentation and coordination. I looked out at the lake. I didn't fight anyone. Preston Calloway built a road on a lake shelf that floods every spring. He called me confused. He called me ma'am. He handed me a business card and told me to have my attorney call his. I paused. I opened the dam gates on February 15th, the same way I've done every year for 6 years. The same way my father did for 40 years before me. I just let spring happen. Nathan nodded slowly. And the rest followed. The rest followed because Preston had already broken the law before I got home from Washington. The road was illegal the day they broke ground. The fraud started the day he created the maintenance district. The environmental violation began the day they poured the first cubic yard of aggregate on that shelf. None of that was my doing. I just stopped pretending it wasn't happening. A Canada goose landed on the lake's surface near the eastern shore, breaking the perfect stillness. I watched it settle. 30 years on the federal bench taught me one thing, I said. You don't need to fight people who are already fighting the law. You just need to wait for the law to catch up with them. Nathan was quiet for a long moment. Then, your father would have appreciated how this ended. I looked toward the northern shelf, buried now under clean snow, native grass dormant beneath it, rocky outcroppings standing clear. The natural shoreline restored, exactly as the photograph showed it in 1978. He would have said I was too patient. He'd have closed the road the first week. Nathan laughed. Maybe that's the difference between engineers and judges. Engineers solve problems immediately. Judges wait until the record is complete. I stood and walked to the porch railing. The lake stretched south for nearly 2 miles, gray and still and immense, ringed by mountains going white with early winter snow. My grandfather's land, my father's dam, my lake. Every inch of it documented, every boundary surveyed, every right protected. Preston Calloway had looked at this lake and seen a shortcut for 180 wealthy homeowners. He hadn't seen the woman who'd grown up swimming in it, whose father had built the dam that created it, who'd spent 30 years on the federal bench learning exactly how the law protected land like this. He'd called her confused. She'd opened a gate, and the lake had done the rest.